The committee will come to order if everyone could take their seats. Mr. Doggett is recognized for 5 minutes.
Thank you, Mr. Chairman. What happened here is outrageous and inexcusable, and unless those of us who strongly disagree with the Tea Party on many issues defend it from any impairment and allow it to be as wrong as it wants to be, we impair our democracy. Mr. George, many charges have been made here this morning. You, as Inspector General under Title V, Section 2, have a statutory responsibility as Inspector General to prevent and detect fraud and abuse in the programs and operations of the IRS, do you not?
That is correct, sir.
And as best I can determine, sir, you have fulfilled that responsibility faithfully and forthrightly. Let me ask you if, using the extensive audit and investigation powers you have as Inspector General, you have found any evidence of corruption at the IRS?
No, not at this time, sir.
Yes, sir. And let me ask you, sir, with your extensive powers, if you have found that our tax system is rotten at the core?
No, definitely not rotten at the core, sir.
Yes, sir. And let me ask you, sir, if you have, using your statutory powers and fulfilling your responsibility, determined that the IRS picks who wins and who loses in America?
I don't believe that is the case.
No, sir. You have not. And the statements that were made in very inflammatory charges at the beginning of this hearing, it is obvious, have no basis in fact, at least any fact that has yet been demonstrated this morning. It is important that in addressing and fully correcting one wrong, we not complete and be involved in other wrongs, such as encouraging the proliferation of secret corporate money, not just the proliferation and pollution of our democracy by that money, but that it be tax-subsidized secret corporate money, that we not permit those who have a fundamental disagreement with the progressive tax system using this incident as a basis for shifting even more of the burden of financing our defense and our essential government services onto working people, that we not permit those who have an agenda that has now been voted 37 times to try to undermine the full and effective implementation of the Affordable Health Care Act so that the health care crisis is ended for families across this country. That's what's at stake here. That's what's been discussed here. It is not based on any fact associated with this investigation to this date, as indicated by the Republican-appointed Inspector General whose job it was to determine whether any of these charges had merit. Now, let me move to an area where I disagree with some of my Democratic colleagues in their comments this morning. I don't believe there's any lack of clarity in the statute here. The statute that is in effect has been in effect for decades, and it requires that before there is tax-exempt status, as Mr. Lawrence O'Donnell, as the Crew Group, the Citizens for Responsibility and Ethics in Washington has pointed out in a petition, you are to be denied this status if you are not exclusively engaged in social welfare according to the statute. Is that not correct? The statute is explicit. It uses the words exclusively. The regulation the IRS adopted 30 or 40 years ago uses different language.
If it's addressed to me,
yes, sir.
Mr. Doggett, I have to demur the Secretary. That's a tax policy question, and I'm not in a position.
I'm not asking you for tax policy. I'm just asking for a clear reading of the statute, and a clear reading of the statute that has been in place for decades and is in place today says that there should be a denial of tax-exempt status to any group that is not exclusively engaged in social welfare operations. And it was only after a regulation adopted long ago, long before any of you were at the IRS, that changed exclusively to primarily, that there was even any discretion for this section to be involved in this operation.
Mr. Doggett, I do know that we have indicated that some clarification from those in the policy area of the Department of the Treasury might be needed in this area to help clarify again?
Well, in April, Citizens for Responsibility and Ethics in Washington filed a petition with the Treasury Department and the IRS to address that. If the statute, the clear wording of the statute had been followed, we would not be having to deal today with selective enforcement. We wouldn't have any problems with enforcement in this area at all. And I hope that that petition is honored and responded to promptly, as I believe you have fulfilled your responsibilities, Mr. George, as Inspector General. Thank you for your testimony, and Mr. Miller, thank you for yours and for stepping aside.
Thank you. Time has expired. Mr. Roscom is recognized.
Thank you, Mr. Chairman. Mr. Miller, you may object to the word targeting, but it's used in the IG report 16 times. So it's a common understanding of the word, and so I would just suggest that it's a well-settled doctrine and we not waste a lot of time parsing on it. You admit that you spoke with Ms. Lerner and Celia Rudy about the planted question beforehand. Can you tell us more about that conversation?
I did not speak to Celia Rody, and I believe I did talk to Lois about the possibility of, now that the TIGTA report was finalized, now that we knew all the facts, now that we had responded in writing and everything was done, did it make sense for us to start talking about this in public?
Can you walk me through the logic that animated in your mind at that time where you thought it would be a good idea to make a public disclosure to the American Bar Association rather than coming and following up on your duty to disclose that to the House?
So we were going to do it at the same time, I believe. Our intent was to talk to you all at the same time.
But that didn't happen, did it?
It did not happen, I don't believe.
What other recollection do you have, or what other experience did you have when you were talking with Ms. Lerner about this scheme to have the planted question at the ABA?
I'm not sure what you're asking, sir.
I'm asking, what's your recollection of that conversation?
We talked about what would be said and how we might do it.
Where did the conversation take place?
I believe it was over the phone.
What day did the conversation take place?
I'd have to look back at my notes on that, sir.
You've got notes on that?
I'd have to try to find them. I'm not
Why
sure
did you
I do.
say you had notes if you don't think you have notes?
Sir, please. I don't.
Please. Do you have notes or don't you have notes?
I don't know.
Okay. Let's shift gears. A little while ago, you were being, you engaged with Mr. Reichert on the question as to whether you knew that this committee, this whole idea of does the committee have the right to know this information, and then you sort of sheltered yourself in this idea of, well, I've always told the truth. Let's set that aside for a moment. Now, you're a lawyer and I'm a lawyer. You know that in the process of discovery, Mr. Miller, that when you find subsequent information, counsel has a duty to disclose that to the opposite party. There's no Perry Mason moments. There's no gotcha moments. There's no litigious situation where somebody comes in and says, oh, we are just showing up, Your Honor, with this information, and we haven't disclosed it to the other side. Don't you acknowledge that you had a duty, based on your testimony before this committee, of what your actual knowledge was? Didn't you have a duty, Mr. Miller, to come forward and disclose that to the committee based on all this cascading inquiries that had happened from the Ways and Means Committee directed to you?
So I don't believe so, sir. What was happening was I was in possession of some facts, was not possession of all facts. We had done an internal review to see what we needed to do to get these cases moving because, again, the processing was bad, the listing was bad. Those are two different pieces we were dealing with. TIGTA was in at exactly the same time. They were getting all the facts. We were going to wait for them to get the facts so that I didn't come in and either mess up their investigation or otherwise give you facts that were not correct, sir.
So you weren't concerned about the timing of the TIGTA investigation when you and Ms. Lerner made the decision to move forward and do the planted question. Is that right?
It was done.
It was done.
We
And
had
so
all
you
the
had
facts, and we had made our written response.
Right, I understand that. So in other words, you had the actual information, the totality of the information that you're describing today. You had it all in your possession at the time at which you were under a scheme with Ms. Lerner to go and do a planted question. Is that right?
I sort of object to the term scheme. We had the information. We were reaching out to the
An
committees at the same time.
understanding, a written or not written down contemplated
reaching out to the
play,
committee
a
at the same
manipulation, call it what you will. You had all of the information, isn't that right?
We were reaching out to the committee at the same time.
Well, what form did that outreach take?
We called to try to get on the calendar.
You called to try and get on the calendar. Is that all you got?
It's the truth.
Okay. You know, I find it incredibly ironic. You know, on the one hand, you're arguing today that the IRS is not corrupt. But the subtext of that is you're saying, look, we're just incompetent. And I think it is a perilous pathway to go down. There's sort of this notion that hasn't been satisfactorily answered, and that is, if the targeting wasn't targeting, if the targeting wasn't based on philosophy, how come only conservatives got snagged?
They didn't, sir. Organizations from all walks and all persuasions were pulled in. That's shown by the fact that only 70 of the 300 organizations were Tea Party organizations of the ones that were looked at by TIGDA.
All right.
But
That
your
is
testimony is in contradiction to the IG testimony. I
All
yield
right.
back.
Time has expired. Mr. Thompson's recognized.
Thank you, Mr. Chairman. I appreciate the fact that we're having this hearing and want very much to be able to get to the bottom of this. More important, I want to make sure, or as important, I want to make sure that we were able to do all that we can to prevent it from ever happening again, for all the same reasons that many of my colleagues on both sides of the aisle mentioned today. And I want to associate myself with the outrageous and intolerable group as to where I think this ranks. What I would like to know, General George, first, in your testimony, you had a section that is titled Results of Review, where you say the IRS used inappropriate criteria for identifying these organizations. Is that legal?
Is it legal? It is.
I'm trying to get a sense of what inappropriate criteria means.
It is not illegal, sir,
Okay.
but it was unusual.
And then you enumerate them. Inappropriate criteria were developed and stayed in place for a total of more than 18 months. Is that illegal?
It is not illegal, but it was inappropriate.
I understand that. I'm just trying to get a sense of.
And, sir, if I may, it's contrary to Treasury regulations and other policies then in place by the department.
Understand. The substantial delays, is that illegal or inappropriate?
It's inappropriate.
And then the third, the unnecessary information, illegal or inappropriate?
Inappropriate.
Okay, thank you very much. You also outline recommendations that you think are most critical and explain whether they are, if enacted, they're enough to prevent this from happening again. Are they?
The vast majority are, and IRS agreed to the vast majority of them.
And do you have some mechanism, some matrix for making sure that they are put in place? And is there a plan to go back and review these and to continue your good work of review to ensure that your recommendations are being followed out? And that your recommendations are enough to protect the citizens of our great country?
Mr. Thompson, you anticipated almost our entire future plan. We are both going to take a look to see whether the IRS has successfully implemented. As you believe you indicated, or someone did, the President indicated that he was going to ensure that the IRS complies with those recommendations, and it would definitely be our intention to follow up to guarantee that that has occurred.
One of the responsibilities that we have is also an oversight responsibility. Is there something in your recommendations and in your subsequent plans that will keep us in that loop? Or are we going to have to find out about this outrageous and intolerable behavior through some other means?
Mr. Thompson, we publish an audit plan each year laying out which audits that we're going to engage in. We request information or solicit ideas from Congress, from the administration, and from anyone who has a tangible role in the system of tax administration. And it is our intention to once again do that, and there's no doubt in my mind that we will follow up with Congress on this matter on a regular basis.
Thank you. Mr. Miller, what are your obligations in regard to reporting this type of behavior to Congress?
I'd have to go back and take a look. I don't believe there's an obligation. What happened here, sir, is we knew TIGTA was in. I knew TIGTA was in May, almost immediately, when we were involved. We had a meeting with Mr. George and company in May where there's an indication they'd be done this summer. Our understanding is they were going to get the facts, they were going to get them out there. There was never the intention or belief that these facts would not come out in full.
General George, is there a need to pass specific legislation that would make it more difficult or hopefully impossible for this to happen again, and to strengthen the requirements for reporting when something this outrageous and intolerable takes place?
Mr. Thompson, I will answer your question in full, but I have to again preface that the Secretary has delegated tax policy questions to the Assistant Secretary for
That's not, it's a
All right.
process question, not
No,
a
no, no.
tax
But
policy.
time has expired, so you can supplement that answer in writing if you wish. Mr. Gerlach is recognized
Thank
for
you.
5 minutes.
Thank you, Mr. Chairman. According to the Inspector General's report, the IRS started its inappropriate handling of certain tax-exempt organization applications in early 2010. And to swing back to some of the prior testimony, Mr. Miller, you indicated that you never spoke, or excuse me, before I ask that question, let me highlight two pieces of media articles that appeared also, one in 2010 as well as one more recently. In September 2010, there was an article in the Weekly Standard concerning the concerns of the Coke industry's attorney that there had been confidential taxpayer information potentially in the hands of senior administration officials that were part of an August 27, 2010 on-the-record background briefing. Subsequently, just a few days ago, there in the USA Today was a column and op-ed by a gentleman connected with the National Organization of Marriage, who indicates in that op-ed that the release of this organization's confidential tax return to the Human Rights Campaign is a canary in the coal mine of IRS corruption, contrary to assertions that the targeting of Tea Party groups was an error in judgment by low-level IRS bureaucrats. The release of this confidential data to a group of this nature suggests the possibility of complicity at the highest levels of politics and government. So back to the questions of whether there was any information sharing of taxpayer records, taxpayer returns with anybody outside of the IRS. Mr. Miller, you indicated in testimony some moments ago that you never spoke personally or communicated personally with anyone in the White House about the sharing of confidential taxpayer information. Is that correct?
I believe so.
Do you have any reason to believe that at some point you did, from, say, January 2010, speak to somebody in the White House or communicate in another way with somebody in the White House about the sharing of confidential taxpayer information?
I don't think that would happen.
So your answer is no, you did not?
I don't believe I did.
Are you aware of any other IRS official from that time period to present that communicated with anybody in the White House concerning the sharing of confidential taxpayer information to somebody outside of the IRS?
So may I ask, can I ask, are you asking whether
I'm asking whether
shared-
you're aware of anybody else in the IRS that ever from January 2010 to present communicated or spoke with anybody in the White House about the sharing of confidential taxpayer information?
So I don't believe so, but what I'm confused about, sir, I apologize, but just so I'm clear of what I'm answering, Are you talking about whether I believe we shared information?
Whether you have information or belief that any confidential taxpayer information, taxpayer being individuals, being organizations, being businesses.
Was shared.
All of that information being shared with somebody outside of the IRS in violation of Section 6103.
I have no knowledge of that.
You have no knowledge of that.
That's a question I understand. Thank you, sir.
You did indicate previously, however, in questioning, that you did speak yourself with Treasury Department officials regarding the sharing of information. I'm not saying the White House now, I'm saying the Treasury Department. If I wrote that correctly, you did speak to somebody in Treasury about that at some point. Is that correct?
I don't think so. I mean, but again, let's be clear.
Did you ever speak, I'll ask the question more clearly and more directly.
Did I ever
Did
share
you ever
taxpayer
speak or
information? No.
communicate with anybody in Treasury Department who was not within the IRS about the sharing of confidential taxpayer information in violation of 6103?
Can I rephrase it and you tell me what?
No,
right.
I phrased
'Cause
the question,
I don't know
you
what you're
phrased the
asking,
answers.
sir. If you're asking me whether did I ever share 6103?
I didn't ask that.
Treasury.
Did you ever communicate or speak with anybody in the Treasury Department not within the IRS about the sharing of confidential information, taxpayer information?
See, I don't believe so, but if you, I don't know whether you're talking about the subject, which would be absolutely fine to talk to them about, or the
That's what
sharing
I'm trying to
of-
inquire about, Mr. Miller. I'm trying to find out what you did, what you knew, and when you knew that, and who you spoke with. So you're saying today that at no time from January 2010 to present did you speak to somebody in the Treasury Department about the sharing of confidential taxpayer information?
No, what I'm saying, sir, is the following. I have
No,
never
I'd like an
shared
answer to my question,
taxpayer
sir.
Information.
Did you ever do that?
Did I ever talk to them about the sharing of?
Talk or communicate? It might have been by email, might have been by fax, might have been...
I don't believe so.
By
but
sign
again,
language.
I can tell you categorically, I never shared information. Did I ever talk to them about the rules around it? I don't think so, but that would be permissible.
Well, were you aware, I think you, to Chairman Camp's questions, you were aware of news reporting about the National Organization of Marriage and the concern they had about the sharing of their confidential information. You indicated on the record that you were aware of that news story. So on that story, any other story, did you talk or communicate with anybody outside of the IRS in Treasury about that issue?
I don't know. I don't believe so, though.
Okay, will you check all of your records, all of your notes,
back on-
all of your emails to get back to this committee about whether your answer is different than what you're providing right now?
Yeah, but what I can say again is
Well, I have a limited
that
time.
All right.
inform-
Time is expiring, has expired at this point. So why don't we move on to Mr. Kind?
Thank you, Mr. Chairman, and thank you, gentlemen, for your testimony here today. I think it's been illuminating and very helpful. Mr. Miller, let me start with you. I assume you agree with the premise that if there is a agency in the federal government that just needs to be above reproach, and no hint of bias, partisanship, ill treatment, mistreatment, unequal treatment to any individual or any organization, it is the IRS. Is that right?
I agree, sir, and that's what's sad about this.
And obviously, the optics of what happened there in the Cincinnati office and reviewing the applications, this is what comes from it. Is that right?
The perception is bad. There's no-
My understanding, too, that based on the Inspector General's report and the recommendations, that the IRS has taken that up and is trying to do their best to implement that to ensure that this does not happen in the future again?
We will implement all recommendations, and it will not happen again.
Mr. Neal asked you previously in his line of questioning about the accountability, well, who's being held accountable and why, and that. Obviously, you've rendered your resignation to the President, and he's accepted that as Commissioner of IRS. Is that right?
I have done so to the Secretary.
Okay. And any other instances of accountability as far as those at the Cincinnati office, those in charge of the Cincinnati office in the development and use of this criteria?
So I think I mentioned that there were two instances in which there was counseling suggested and there was a reassignment of someone. But what I should say, and what I said in my opening statement is, we now have possession of the facts with respect to the TIGTA report. Now is the time we should be looking at that.
Is there
Once
any,
we have the facts.
any pushback from the IRS with the Inspector General's report and some of the recommendations that they're making? Any difference of opinion?
There's no air between us on the recommendations.
Okay. Is there a role for the Congress to be working with the IRS to ensure that something like this does not happen in the future? I'm thinking specifically of Post Citizens United and 70,000 applications that was submitted, and a doubling, I understand, of C4 applications too. Do you feel there's sufficient personnel in order to expedite the review of these applications?
There are not sufficient personnel.
Of course, I don't think we'll have many recommendations on the other side as far as allocating more resources to the IRS so you're sufficiently staffed in order to deal with the huge influx of applications that the IRS is experiencing right now. I think there is a role for the Congress, and we've got to share some responsibility as well. But, Mr. George, let me ask you. I think part of the problem is the definition of the criteria of primarily engaged in social welfare seems to be an inherently subjective criteria with no clear, bright lines or clear rules. I think the IRS was trying to further define that for the division in Cincinnati, but is there further tightening of that definition which would be helpful to IRS personnel when it comes time to review the applications?
The answer is yes.
Is that something that has to be done internally with IRS, or is there a role for Congress to intervene and try to help further define and present some more objective and bright line rules when it comes to reviewing social welfare applications?
It's my understanding that the IRS has the authority to do this on its own without legislative fixing.
Okay, I think obviously this committee will need to be working with IRS too to ensure that that gets done, because otherwise it's going to be an inherently flawed human process of subjectively applying this criteria, I feel, especially with the huge influx of applications. Now, some of this has been delved into, but I think it's so important that it needs to be reiterated. Mr. George, I apologize if you think you've made yourself clear on it, but according to your report, you found no bias or partisanship behind the development and the use of the criteria for selecting applications from the Cincinnati office. Is that right?
That is correct, sir. But we did find gross mismanagement
Right.
in the overall.
That's clear in your report, too. Did you find any evidence that anyone outside of the IRS was involved in the development and the review of
Not
these
at this time, sir.
Not the White House or Treasury?
That's correct, sir.
Thank you. Thank you, Mr. Chairman.
Thank you. I will recognize Dr. Price for 5 minutes.
Thank you, Mr. Chairman. I think if I'm sitting at home trying to figure out what's going on here and listening to the testimony and the remarkable revelation in some of these questions, you get some snickers after some of them, but you have the federal government asking what books you read, have the federal government asking whether or not you know anybody in your organization that's going to run for political office. This is chilling stuff. This is very, very serious. Mr. Miller, do you accept the findings of the IG report?
We do, sir.
One of those findings is that groups were targeted. Do you accept that finding?
I would not characterize it as targeting, but
You can understand why others would believe, including the Inspector General would believe, that groups were targeted.
I think the groups that were put into the centralized grouping would have
Targeted.
gone in. They would have gone in whether we had done the correct thing or were we using.
You've described the list of criteria being used to identify these groups as obnoxious, correct?
Correct.
And it's not just Tea Party groups, right? It's not just conservative groups. In fact, there are religious organizations, are there not?
I don't know that, sir.
Are you not aware that there are religious organizations that were identified by the list of criteria that were formulated?
I'm actually unaware that there were, and I say that as though I don't know. I've looked at the list, but very quickly.
Are you aware that there were some Baptist church organizations that were identified for greater scrutiny? And
I was not aware of that, sir.
who's Sarah Hall Ingram?
She is an executive at the Internal Revenue Service who does the Affordable Care Act work for us.
That's where she works now.
Yes, sir.
Where'd she work during the period of time under question here, 2010 to 2012?
Someone has corrected my prior comment, I think. So 11 and 12, I think she was already working on Affordable Care Act. I don't know when in 10 we made that.
Did she ever hold the title of Director of Tax-Exempt Organizations for the IRS?
She held the Division Commissioner title.
So she had responsibility over much of the concerns and discussion that we're having today. Is that correct?
At the time, she was Division Commissioner, yes.
So would she have known about this list of criteria that has been formulated, had been formulated?
I have no reason to believe that she would.
That she would?
Yeah. I have no reason to believe that she would. I'm sorry if I wasn't clear. I don't think so.
You don't think she knew about the criteria of the folks under her responsibility?
There are a couple of thousand folks, and
Have you ever had that conversation with her?
no.
You've never asked her whether she knew.
So I'm not sure she was in that job at the time, sir.
And you identified her current position as one with the IRS oversight over the ACA and the regulations related to the ACA. Is that correct?
Correct.
Who appointed her?
I moved her into that job.
You've also said that in the context of the criteria list and what we're talking about today, that the IRS, quote, provided horrible service, unquote. Correct?
I think that's correct.
That's what you said earlier today. And the individual who was overseeing a portion of this and had responsibility for the provision of this, quote, horrible service, now sits over the entity at the IRS that will determine whether or not people are complying with the rules of the ACA. Is that not correct?
No, I don't think it is, sir.
So Sarah Ingram is not at the IRS over control of the regulatory
She was
authority
for
of the ACA?
at most a period of this time, but we'd have to go back. I don't think your timeline works perfectly, sir. I'd have to go back and check. There may be a period of time when she was still in that job, but she had transferred
Mr.
over.
McDermott, in questioning you, said the IRS wouldn't have any access to medical records. Is that correct?
I believe that's correct.
So it would be unnecessary for them to gain access to medical records, correct?
I can't,
Be unnecessary?
I think so.
Isn't that how you described the questions and the information that the IRS folks were gaining through the criteria list? Unnecessary?
I think if you are you talking about the letters that
I'm saying
came
that
out?
there is a parallel here in the expansive nature of what the IRS has done. Would you care to recharacterize the unnecessary word? Is it illegal what they have done?
It is absolutely not illegal.
It's not illegal what the IRS has done.
Here, so let me understand the question. What is your statement as to what is illegal?
Do you believe it is illegal for employees of the IRS to create lists to target individual groups and citizens in this country?
I think the Treasury Inspector General indicated that it might not be, but others will be able to tell that.
What do you believe?
I don't believe it is. I don't believe it should happen.
Thank you, Mr. Chairman.
Please don't get me wrong. It should not happen.
Thank you. Mr. Blumenauer is recognized for 5 minutes.
Thank you, Mr. Chairman. And I appreciate the opportunity for our being able to listen to the witnesses and try and develop the record, and people putting forth their own ideas, their own questions, clarification. I think, Mr. Inspector General, that you have provided a tremendous service with the report, straightforward, identifying mismanagement, inappropriate activity, and I hope that people will be able to actually read the report, to reflect on it. I appreciate your being here, Mr. Miller. It's not the most comfortable. I appreciate that you, as a career civil servant, accepted responsibility even though you hadn't done these things directly, and resigned. I mean, it's an air of responsibility you don't often see in the political arena, I will say. But I am hopeful that we can continue to probe, to direct, to make sure that no political entity is subjected to inappropriate activity on behalf of the IRS. I appreciate some of my colleagues talking about efforts that we can do to clarify laws and regulations together to be able to make sure that there is less ambiguity and that there are better standards. But I also think at some point it will be interesting to reflect on Congress's role in what the chairman referred to as, in pretty strong terms, about a tax code. When I came here in the 104th Congress, there were 114,000 employees in the IRS. Since I've been here, Congress, in its wisdom, has expanded the code, made it more complex, and cut dramatically the men and women who are on the front lines to deal with it. Their inadequate training budget. We've had this testimony just across the Capitol before the Senate this last week. And I really hope that there's an opportunity to think about how we support the integrity of the Internal Revenue Service, not just by making sure there isn't inappropriate or gross mismanagement, there is accountability, there is clarification, but we rely on it to be able to function. And Congress has slowly been starving the budget of the IRS at a time when each dollar spent on those employees gives the federal government about $214 in revenue. And for us to not make sure that it's adequately staffed, adequately trained, adequately equipped, invites shortcuts, makes it harder to have the oversight and the accountability, and harder for overall performance. I think it's inexcusable to cross the line. I think it's important that we bear down, we understand, we make sure it doesn't happen again. But I also think as the Congress has made the code more and more complex, given the IRS fewer and fewer resources to administer it, make it difficult to train, I think it undermines the ability to take a complex entity that relies on self-reporting and people having confidence in it. And I'm hopeful that this isn't something that we slide past. I appreciate, Mr. Chairman, your interest in simplifying and reforming the code, but I also hope that we look at the task they've been given, the budget they've been given, and think a little bit about maybe a rate of return that would more than pay for itself if we invested in training, in management, and having more than 150 people to deal with the avalanche of these applications. I guess that wasn't so much a question, but it is something that occurred to me, and I know, Mr. Miller, you had referenced the stress that that group is on and how hard it is to keep track. And at some point, if you would provide to the committee, not putting you on the spot now, but some reflections on what it would take to do this right, I think it would be a valuable part of the committee record going forward, because we all want it to have integrity, we want it done right, we want to treat our employees and the taxpayers properly. Thank you.
Mr. Buchanan's recognized.
Thank you, Mr. Chairman. Mr. Miller, I want to talk a little about the culture of the organization. I was looking at the note, your bio, 90,000 employees, $12 billion budget. You've been there 25 years. I'm concerned, and I guess to start off, we've got a mission statement there. I'm very concerned about the breadth and the depth of maybe what's going on. I think a lot of employees probably do a good job, but I've been a person that's been in business 30 years and run larger organizations. So you've got a mission statement in terms of talking about working for the American people, doing what's right, playing by the rules. Is that something that's internalized at the IRS, or is that just something on a website?
So I believe, Congressman, it's internalized, and the vast majority of our folk are hardworking, incredibly honest people. I'm going to tell you, and you guys should hear, that as these discussions occur, it's damaging to the morale of those people. It's probably ultimately damaging to the sense of voluntary compliance, which underlies our entire tax system. And
Well, let me just say, I think there's probably a lot of good people, but at the same time, we've got a massive PR problem at minimum.
We do.
And this has got to be dealt with quickly, and it can't just drag on for 6 months to a year. So I think we need to get to the bottom of it. The other thing, let me just ask, in terms of that size organization, who's in charge? Who's the boss? How is that hierarchy? How does it work? I ran a very decentralized business where I had a corporate structure, but I had managers and partners in different operations. How is the IRS, in terms of being an acting commissioner? You've been there 25 years. Who do you report to, or the commissioner, ideally in the past, who do they report to? And at what point, when something like this comes up, who's involved at the next level up?
So the reporting chain in the organization is, there are 2 deputies, and reporting to the commissioner, and the commissioner reports to the deputy secretary of Treasury.
Who's ultimately responsible?
The commissioner, acting commissioner, not the Treasury. The Treasury relationship is such that they would not be involved.
So who would be responsible for you? Who basically asked you to resign or fired you?
It would be Secretary Liu.
Secretary Treasurer. The other thing is, let me ask you, there's been 2 people that have been, were you terminated or fired? What happened there? Or are you getting ready to retire?
I was asked to resign, and I will retire.
Okay.
As under the civil service rules.
Now, on what basis do you feel like you're getting asked, and maybe one other person, I guess, got asked, but it seems like there's a lot of other people, ideally in Cincinnati and Washington and other parts, that haven't been held accountable?
I'm not sure what the question is, sir. If I could answer it and then tell me if I'm answering the wrong question.
Okay, go ahead.
We're not done yet. We're not. We now have the Treasury Inspector General's report. We now have the sense of the facts. Now is the time for those that remain, including the incoming acting commissioner, Mr. Werfel, to take those actions.
Let me mention, as it's been brought up with a couple of the ladies that work with you, Lois Lehner and Sarah Ingram, what's being done about those 2? Because they've been in the press. There's a lot of concern about that. They ran a large operation, and it seems to be at the heart of the issues today. I think that's got to get dealt with in a very aggressive, clear way in the next week or 2.
I don't know whether it will be or not. That will be up to the new acting commissioner.
And let me just ask you, in terms of the new acting commissioner, are we looking to get a permanent commissioner, or is this going to be, for a period of time?
I don't have that information. I would assume, however, that we ought to have a nomination. And
I hope, because I think at the end of the day, that leadership matters, and getting the right culture, the right environment within the organization, the IRS, it needs incredible leadership and incredible integrity. And we need to make sure that that person, not so much the acting one, but the permanent one, is the right person going forward. I yield back.
I very much agree, sir.
Ms. Schwartz is recognized for 5 minutes.
Thank you, and I appreciate the opportunity to ask a question. Let me just say a couple things and then ask a question, and I will attempt to be brief. This is not easy hearing for you or for us. We are outraged on behalf of the American people. That's number one. The American people deserve to be able to trust their government for fairness and lack of bias, and that was violated. And that violation is outrageous and unacceptable to us, and I hope to you. And the fact that number 2, there need to be changes. It's already happening, some changes you're making, but we need to be assured that those changes we made. Things happen, investigations have to be done, and then changes have to be made to assure the American people that we know that and we will not accept bias or discrimination in any way. I think that is clear to all of us. The second thing I will say is that this committee and Congress also has a responsibility to do this in our own questioning and our own demand for accountability and transparency from you, from the administration, from anything that happened, to do it in a way that is not political either. And I think we have to be very careful about that, and I would compel all of my colleagues to make sure that we also engage in this in a way that is clear and fair and non-political. This is, we all agree that something has to be done, we should do it. So my question, though, is really about sort of more broadly what's going on in the divisions that handle the applications for nonprofit status. I have heard in my own office that groups come to us that have applied for nonprofit status, mostly 501c3, not C4, which was the issue here. But the backlog of a year, they don't understand why it takes so long. They don't understand why they are not clear about what's wrong with their application. They're not hearing back. And given some of the cuts that we've made, nonprofit groups in particular, the ones that are not the 501c3 in particular, but really are looking to try and make up some of the gaps that are here, to be able to raise money and charitable contributions and to make a difference in our communities. And I, for one, need to have better clarification about what the criteria is, why don't they hear back, why those applications are taking longer than a year, if there are problems with them, what kind of questions you legitimately can ask and ones you can't, and how we can move this process forward. And I think that we have every reason to ask those questions and to get that kind of answers on behalf of our constituents. And then again, it goes for all of the nonprofit organizations. If there are reasons to review an application in greater depth, and there may well be, certainly we have to understand that better, and so do the people making those applications. They should not be in the dark about the criteria. They should not be in the dark about why it's sitting on somebody's desk or receiving more review. So if you could clarify for us now, Mr. Miller, or give us some more information as we go forward about what that criteria is and what we can expect and what we can explain and how we can help you make sure that you are doing this right, that when they mess up, Mr. George, you're in there and doing that investigation and getting those answers and correcting those, and we can assure the American people of the right process, the fairness of that process, the criteria that's being used, and a timely, appropriate, responsive process to American taxpayers and certainly to hopeful nonprofit organizations. So if we have a chance to answer that, it would be appreciated.
And I think probably it's a big enough question that will follow up in writing. But the process right now is as I've mentioned, we have a limited number of people, 140 to 200, that work on the 70,000 applications that come in for tax-exempt status. Most of those are 501c3 organizations. Now, 501c3 organizations get a number of tax benefits. They get deductibility of contributions. They get the ability in some instances to issue bonds. They get state tax exemptions, property tax exemptions, postal rate reductions. There are significant benefits in addition to just tax exemption. And we have to look at them. We do. And many of them are small organizations that should go through very quickly, and some of them are large organizations that we need to take a look at. The largest hospital systems, the largest universities, there are some large organizations. Then you look at particular issues within them. And we will look for, is there enormement? Is there private benefit? Is there political activity going on? Because again, C3s, no political activity is permissible. C4s, some, but not a primary amount of activities can be political in nature. Those are things that take time. We try to move them along as fast as we can. We do not have enough people right now.
Yeah. So do you feel like you don't have enough staff and but you're clear about the criteria and that criteria?
I'm afraid time has expired, so you'll have to respond.
This will be a continuing conversation.
Yes.
Thank you.
Mr. Smith is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Miller, could you define political activity as it would relate to the agency and the applications?
Under the Internal Revenue Code, political campaign activity has some definitional limits. You need a candidate. You need a candidate for public office. And that's sort of what you need for it to be a political campaign activity under 501c3 and 501c4. A little different under 527 rules.
And was it the concern about political activity that led to the centralization organization of reviewing the applications?
I believe it was. It was the fact that we were seeing more applications indicating that they might be doing political activity, and it's an area that is very difficult for us. Is it education? Is it an issue ad? Is it actual campaign intervention? Those are very difficult for us to parse out. The decision was made to try to get them into one group and educate those people. How they started that process was one of the problems here. The other problem here, as I've mentioned, is the method of processing these cases was flawed. And I think that the TIGTA report and Mr. Russell's report goes into great detail on the problems that we saw in terms of the lack of communication between pieces of the service, the letters that were going out that were overly broad, and the complaints that we were getting rightfully from those who were given a remarkably little amount of time to explain an awful lot of stuff.
And how many employees at the IRS would you say would have been associated before the centralization and then after the centralization?
I'm not sure of the question, sir.
The number of employees associated with the applications were greater in number before the centralization. Is that accurate?
It might be. I don't really know the answer to that. It might have been the same X number of people, but they were centralized versus spread out.
Now, it was mentioned earlier in testimony and in questions that donor lists were requested by the IRS. Is that accurate?
That's accurate. In some cases.
In some cases.
Not all these cases by any stretch of the imagination, sir.
And did the acquisition of those lists ever lead to additional, or did those lists trigger any further inquiries or new inquiries?
No, I believe what happened is when they hit the paper, we discussed it. We told people to look, I'll go back for a moment. Donors can be relevant, but they certainly shouldn't be in every case. They shouldn't be asked in every case, because they can be relevant if a donor has a contract with the organization, if the donor is doing it for a political purpose, but to just ask for donors without a rationale shouldn't be done. When we saw that it happened, we asked that, if they hadn't sent them in, we reached out and said, don't send them in. If they had sent them in, we said, we're not going to use these, and we didn't. You will not find them used in any of these cases. There was something, I don't know how many of these cases there were, maybe 30 or something like that is my understanding. I could be wrong on that. More than half of those were not Tea Party cases that got these donor list requests, by the way.
Okay.
But going back, it was overly broad. It was not necessary.
Thank you, Mr. Miller. Mr. George, I'll ask you the same question. In the cases where donor lists were requested, was it your finding that those lists perhaps triggered further inquiries?
While I don't have an answer to that aspect of your question, Mr. Smith, I do know that 27 donor lists were requested.
27 donor lists were requested.
Correct.
Okay. Mr. Miller, on the safeguards against bias, I think the underlying concern of this entire situation is that bias was applied. And can you share whether there were safeguards in place that were not honored to try to prevent the bias before this situation came about?
So obviously, I don't think, and again, whether it was bias or perception of bias will play out over time. Let me tell you that we have something on the exam side of the house that has worked remarkably well, and that is before anybody gets selected for examination by reason of political activity, it goes through a committee. So no one person can do this. So, and that cuts down on the bias. We do a better job of precisely explaining why we're doing it. On the determ side, less so. So what we've done is elevated the issuance of the criteria to a higher level in the organization.
Thank you. And Mr. George?
And I would just point out, sir, of the 27, 13 were from Tea Party groups of the donor lists.
Donor lists. Okay.
All right. Thank you. Time has expired. Mr. Davis is recognized.
Thank you very much, Mr. Chairman, and I want to thank both of you gentlemen for being here. Everybody that I've heard make a statement or comment, every reviewing body that has had an opinion have suggested that obviously there was some behavior on the part of senior level IRS staff that was unwarranted, unacceptable, intolerable, and of course should never happen again. It's also clear that there have been management challenges, such as who has the authority to do what relative to policy, as well as operational procedures. Mr. George, let me ask you, when did you start the audit?
Our audit, sir, began with a request from a congressional staff member in, I want to give you the exact date, sir, and I do have that here. March 1st of 2012 was when we were initially contacted by a government reform staff member, and our audit began in roughly May, or March rather, of 2012. I mean, we had meetings prior to that, but I would point to March of 2012.
Mr. Miller, when did you first learn of the audit or know about the audit?
Sometime in that same time frame. It would have been in March when we certainly were aware that TIGDA was taking a look at this at some juncture at that time.
And so you knew that this was underway pretty much from the beginning?
I did.
And did it ever occur, perhaps, to have certain kinds of conversations, interactions with whoever would be determined as your superiors?
I mean, I'm sure Mr. Schulman knew. I'm not sure that anybody above Mr. Schulman knew.
Let me ask you, Mr. George, during your investigation, we've heard all kinds of allegations. As a matter of fact, some people have even been suggesting that a good thing to know is who's going to be the next person to go to jail, who's going to be indicted. During your investigation, did you or was it reported to you by any of your investigators that there was any apparent criminal intent or activity on the part of these employees?
Nothing out of the review, the initial review of the audit to that effect, Mr. Davis, but there will be subsequent review on our part on this matter.
You know, after listening to all of the discussion and reading all of the information that I've read, I am not convinced that this is a great big political conspiracy. I would certainly admit that there has been some ineptitude. There has been some lack of serious management procedures used and adhered to. Let me ask both of you, since you've had considerable experience with the Internal Revenue Service, what would be your recommendations to the new commissioner coming in? As Miller?
There's no question that this has damaged the reputation of this organization, and the new commissioner needs to take steps to ensure that we've restored that trust that's so essential. And that's where he or she should take action.
George?
And I would point out, sir, and this is one of the recommendations that we make, training is necessary at all levels on a repeated basis of IRS staff, and especially in terms of the political season, you have a lot of turnover, especially at lower levels at the IRS, and people simply need to know and to be kept up to date rather, of the new regulations and requirements.
Thank you very much, Mr. Chairman, and I yield back.
Thank you. Mr. Schock is recognized.
Thank you, Mr. Chairman. I'll begin by saying that I am most concerned that the IRS's attempt a week ago to clean up and apologize for abusing conservative organizations seeking tax-exempt status is really the proverbial tip of the iceberg. The IRS's stellar reputation of being above partisan politics has been shattered by these revelations, and these revelations now seem to be far from complete. The IRS at first revealed that the words Tea Party, Patriots, and a few other phrases triggered extra scrutiny. Since then, more and more revelations have come to light. Mr. Chairman, I have with me a 150-page document given to me by the Thomas More Society detailing a number of pro-life organizations throughout the country which, in application to 501c3 status, were given horrible instances of IRS abuse of power, political and religious bias, and a repression of their constitutional rights. I'm going to submit these documents detailing what these organizations went through to the Treasury Inspector General for Tax Administration, asking for a reply to this committee about the degree of abuse these organizations received during their application for tax-exempt status. I would like to just highlight a few of those purported abuses and ask for your opinion on them. In a letter from the IRS Office of Exempt Organization Specialist in El Monte, California, specifically the Pacific Coast Division, I would note this is not in the Cincinnati Division, to the Christian Voices for Life of Fort Bend County in Sugar Land, Texas, dated March 31st, 2011, that I have here with me today. They were asked specifically, again, this is a pro-life group, in your educational program, do you do education on both sides of the issues in your programs? Mr. Miller, your knowledge of the 501c3 application, is that an appropriate question to ask?
So I'm going to be honest, and I'm not going to be able to speak to a specific development letter in a specific case. I don't know that I can do that under 6103.
Okay, let me ask you about another letter that was received by a pro-life group, this one in Iowa. Their question specifically asked from the IRS to the Coalition for Life of Iowa, quote, please detail the content of the members of your organization's prayers. Would that be an appropriate question to a 501c3 applicant? The content of one's prayers.
It pains me to say I can't speak to that one either, but that's an...
You don't know whether or not that would be an appropriate question to ask an applicant?
Speaking outside of this case, which I don't know anything about, it would surprise me that that question was asked.
And finally, during another applicant's conversation or back and forth, they were asked specifically, quote, please detail certain signs that may or may not be held up outside of a Planned Parenthood facility, end quote. Would that be an appropriate follow-up to an applicant for 501c3 application?
Again, I don't know what the context would be, but again, it doesn't sound like the usual question.
Thank you. Well, hopefully, Mr. George and the Inspector General's office can enlighten us. Mr. George, during your investigations, are you aware of the 3 letters submitted by Senators Baca, Schumer, and Durbin, written to the IRS, specifically Mr. Schulman, asking them to give extra scrutiny to 501c4 applications?
I am aware of it, but I don't know the details, sir.
So in your investigation so far, in questioning employees of the IRS, did you ask them specifically whether or not these letters from sitting United States senators influenced or impacted their decisions around these cases?
I do not believe that was part of the inquiry, sir.
Will you ask those questions in the future?
I will ask that if appropriate. We will certainly do so if appropriate.
Thank you. Mr. Chairman, I'm particularly troubled by some on this committee who seem to want to rationalize or justify the inappropriate behavior by the IRS in these cases by their disagreement with the Citizen United ruling of our Supreme Court. I think we all know that our nation is a nation of laws, and we either abide by those laws or not, to our peril. And whether we agree with the Citizens United ruling or not should not be justification for this agency, which is charged with upholding the rule of law equitably for all people in all groups, regardless of party affiliation or motive. Specifically, Mr. Miller, I was troubled by your comment that you found this grouping, Mr. George with the Inspector General's office calls it targeting, to be inappropriate but not illegal. I'm wondering if you can give me examples of other targeting within the IRS that you're aware of that would be inappropriate but not illegal.
So I probably, Congressman, should tell you that I don't know. It's my belief that what happened here wasn't illegal, but I suppose there are some facts that might come out that would indicate otherwise. But it's not my area. I don't know, but it certainly was inappropriate, no question about that. I'm unaware. We have used listings elsewhere.
Can you give a few examples?
Credit counseling organization would be one of those that we used a name to pull those cases together to work in a consistent and fair manner.
All right, time has expired. Ms. Jenkins is recognized.
Thank you, Mr. Chairman. You know, we've heard a lot of outrage, a lot of anger and disappointment, but I have to tell you, after sitting here for a couple hours, I'm sad and I'm sick to my stomach that Americans could be targeted by a government agency based on their political beliefs. Mr. Miller, In response to Congressman Nunes, you mentioned that you had a discussion with Treasury, someone at Treasury, regarding the TICTA report. I was just wondering if you could give us more details about when that conversation occurred and with whom.
So I don't know the precise date, but it would have been very recently after the report was done. And I think Mr. George can speak to when he indicated to some parts of Treasury as well. It might have been in the same time frame.
So would that have been the first time you had a discussion with someone from Treasury about this situation?
This situation being the listing and the treatment of these cases?
Correct.
I think so.
So out of all of the news reports that have come out in the last couple years, there was never a discussion at IRS with Treasury about the situation until just recently?
You asked the question was the TIGTA report, and the TIGTA report was described and discussed with them recently. I don't believe the specifics were described or discussed with them earlier, but I don't know that. They weren't by me, I don't think.
Okay. Who was your conversation with?
I would have talked at some point to Mr. Patterson, the Chief of Staff, and subsequent to Mr. George's discussion with Mr. Wolin, I spoke to Mr. Wolin.
You spoke with whom?
Mr. Wolin.
Mr. Wolin?
Wolin.
And how did that conversation go? What did Treasury have to say?
We just talked through the troubling nature of the reports. I indicated that we had worked on fixing the problem, and that's what we talked about.
They didn't give you any advice and counsel on how to...
No.
Okay. Mr. George, how often do you meet with Treasury leadership and IRS leadership regarding open audits?
With the IRS leadership, we meet monthly with the commissioner or acting commissioner on a standing basis, and then we'll have communications as necessary. The secretary holds a monthly meeting with bureau heads, and in conjunction with those meetings, I meet monthly with the general counsel of the Department of the Treasury, and then on an as-needed basis with the Deputy Secretary, Mr. Wolin.
Okay. When did you first alert Treasury leadership and IRS leadership about this specific audit?
I alerted then Commissioner Shulman on May 30th, 2012. I subsequently alerted the General Counsel of the Department of the Treasury on June 4th, and subsequently, and I do not have the exact date, alerted the Deputy Secretary, Neil Wolin, about this matter. And then upon his assumption into the position, I mentioned it to Secretary Liu.
Okay, so May 30th would have been the first time that Mr. Shulman would have known about the troubling allegations.
From my perspective, I would assume that people within the Internal Revenue Service would have given him a heads up about this troubling matter, but I can't say that for certain.
Okay. In your report, you indicate that the decisions to target Americans based on political beliefs were made only within the IRS. How did you determine that?
These were through interviews with IRS staffers both in Cincinnati, Ohio, as well as in Washington, D.C. at the headquarters of the Determinations Unit and the Exempt Organizations Unit.
So did you interview Mr. Miller?
We did not interview Mr. Miller.
So how would you know, or did you interview anyone at Treasury?
We did not, and the reason for that is because at the time of our interviews, we had no indication because this was an ongoing matter, and we didn't have any indication from those initial interviews that they were implicated in this matter.
So had anyone given you any indication that you needed to visit with someone higher, you would have had the authority to do
Most
that?
definitely.
All right, time has expired. Mr. Paulson's recognized.
Thank you, Mr. Chairman. There have been a lot of news reports this week that this has been a bad week for the president or a bad week for the administration, but I will just tell you after hearing additional testimony this morning myself that this is a bad week for America. That's the bottom line. And when supposedly neutral actors in our government choose sides, and the results end up being highly corrosive to our democracy, this is a violation clearly of the trust of the American people. Mr. George, your report indicated, and you've testified, that the IRS improperly requested donor lists from targeted organizations. Obviously, that's a concern from the perspective of pattern of behavior at the IRS based on the report from delays of applications and targeting and also the dissemination of confidential information. But let me ask you this. How long did the IRS, because you acknowledged this just earlier from 27 different organizations, how long did the IRS have in its possession these lists, these improperly lists that they shouldn't have had in their possession from 27 different organizations?
Congressman, they did not indicate, and we did inquire, the length of time that they maintained that information, but again, that they did acknowledge that once they realized they should not have collected it, they destroyed it. But I do not have a direct answer as to how long they held on to it.
Mr. Miller, do you know how long the improperly obtained lists were in the IRS's possession?
I don't know, and I look, the letters were bad. They were just way too broad. Should they have asked for them? Probably not. Was it bad intent or bad management? My guess and my understanding, bad management. When we found out about it, we reached out to people who hadn't sent them yet, and we told them, don't send them. We went to people who had sent them and told them we're not going to use them unless we need to, and we didn't. And at that point, my understanding is that we did not use them in any of those cases, and they're not being retained. They would have been destroyed in the ordinary course of our records retention rules.
Mr. George, were you able to confirm that the lists were actually destroyed, and if so, how were you able to confirm that?
It's through the testimony, the interviews that were conducted by our auditors. Now, I have to admit that that was not done under oath, but we have to go by what we were told by the employees.
Mr. George, do you have any idea how many donors were involved as a part of those lists?
Again, 27 is my understanding of the list of donors requested. Okay. So within the list, I'm not sure. But as I pointed out, 13 of the 27 were from Tea Party groups.
Okay. Mr. Miller, let me ask you this. Is it IRS practice to ask about a group's relationship with a specific person who's not a part of an organization that is applying for nonprofit status as a part of an application process?
So it can be, depending on the facts, based on, is there a contractual relationship that could be an issue? Is there undue influence going on in some fashion that, you know, for example, we would be looking at enormment, we would be looking at private benefit. The one other thing, I want you to know that the donor lists, because I want to just make it clear, 13 were Tea Party, but I believe, and my numbers are just a little different, 2 one way or another. But the Tea Party ones include 9/12 Patriots. The listing folks were the minority of the people who got the donor questions. I just want to clarify the record there.
Sure. Mr. Miller, has the IRS ever asked the question of an individual? Have they ever asked, what's your relationship with John Doe when they ask an organization is applying status? Is that a common practice? Have you asked that question?
I'm sorry, can you rephrase that, sir?
Well, Mr. Teaberry was going down a line of questioning earlier about a lengthy process of a questionnaire that was filed with an organization, and the IRS had asked the question on number 26 of an individual, provide details regarding your relationship with this individual. Is that a common practice? Does the IRS normally do that?
So I don't know what we're talking about there, and it's on an individual case, and I really should not and cannot speak to an individual case, sir. I'm sorry.
Would it be safe to say that knowing that that's probably inappropriate, would there be repercussions or some sort of discipline that might be followed up if that was determined to be inappropriate on that type of a question?
It would depend on the context again, and I don't have the context, and why it was asked, and was it a lack of controls, and was it a mistake, or was it something different than that?
Thank you, Mr. Chairman. I yield
Right.
back.
Thank you. Mr. Marchand is recognized.
Mr. Miller, let's go back to the IRS planted question issue. When was Cecilia Rhodey told to ask the question?
I don't have, exact knowledge on that. I did not do that.
Who told her to ask the question?
I don't know, actually. I'm not sure. Might have been Lois Lerner, but I really am not sure.
What did you tell her about the background of the issue?
What did I tell who?
Rhodey.
I did not have any conversations with Celia.
Did anyone give her a copy, an advanced copy of the IG's report?
Don't believe so, but again, I did not have those conversations, but I would be shocked if that happened.
And how long did she know about the report before the committee knew?
Again, you'd have to ask the people who had the conversation, but again, it would shock me if she knew anything before she had the conversation with whomever she had it with.
On March the 28th, I wrote the commissioner a letter that basically asked him whether local Tea Party groups in my district were being harassed or given lengthy questionnaires and were being discouraged from seeking tax-exempt status. That was March 28th. On June the 22nd, I got a letter from Mr. Grant that basically gave me a lot of assurances that nothing like that was taking place and that nothing out of the ordinary was going on and that they were following just regular order. Then, following a timeline, shortly before my first letter, Mr. Bustani asked in a hearing, of oversight hearing, if there was anything going on over at IRS about these applications. And he was told by Commissioner Schulman, I can give you assurances there is absolutely no targeting going on. Following that same timeline, on July the 25th, we had another Oversight Committee hearing in which Commissioner Miller and I had an extended conversation about this very subject. And that conversation is in this transcript. Anyone can get this on the internet and can read the questions, but the questions were very specifically about Tea Party groups and their difficulties in getting their tax-exempt status, the lengthy conversations that they were having, the questionnaires that they were having to answer. And again, Mr. Miller, in that exchange that you and I had, I came away from that with, I felt, the assurances by you and your office that there were no extraordinary circumstances taking place and that this was just a backlog and there was nothing going on. Mr. Miller, was that your impression of the hearing that day?
No, sir. What I said there and what I understood your question to be was, again, we divide this world in two. There's a question of the selection process, and there's a question of what was going on at the time of your question. At the time of your question, what was out in the public domain and what I thought we were discussing was the letters, as you call the questionnaires. Those were the overbroad letters that have been referred to continuously here. Again, I stand by my answer there. There was not, I did talk about the fact that we had centralized, I believe, I have to take a look at it, but I was talking about the fact that we had fixed that problem, and that's...
But at that time, you knew by that time that there were lists being made, there were delineations, there was discrimination going on, and that there were steps being taken to try to correct it, but you knew that it was going on at that time.
We had corrected it. TIGDA was taking a look. At that time, my assumption is TIGDA was going to be done with their report that summer. I was not going to go there because I did not have full possession of all the facts, sir.
Well, this is a list of questions that, in my case, my local Northeast Tarrant County Tea Party was sent. And it's a list that most taxpayers would not answer and most taxpayers should not have to answer. But it asks some questions that should have never been asked. A printed copy of every page of your website, every tweet from your Twitter account, personal resumes from all your board members, copies of every flyer you ever made and every flyer any guest speaker ever handed out. Explain your relationship with True the Vote, a copy of every single email ever sent by our group. This is a list that is overly burdensome, and in my case, it has led to a deep discouragement on these parties, and it has limited their ability to educate the public. Can I find out, as a member of Congress, the groups in my district that have applied for and either been denied or their application continues to be in suspension?
With Mr. Camp's help, you could, granting us 6103 authorities.
Yeah,
But the application process, until it's done, is 6103 information.
Right.
And if it's denied, then there is redacted versions going out, and if it's approved, then everything becomes public. So within the constraints of 6103, which Mr. Camp can grant you the ability to see, that could happen.
Yield back.
Time has expired. Yes, I think there would be restrictions on my sharing that with Mr. Marchant, however. So Ms. Black is recognized for 5 minutes.
Thank you, Mr. Chairman. And I want to go back to what Mr. Paulson said a few minutes ago, because as I sit here and listen to this testimony, having read the report and multiple sources of information that are now coming out, I got to tell you that the trust for the IRS to begin with was already shaky by the American people. And I know whenever someone gets any piece of information from the IRS, it doesn't feel very good, and they're not very confident, even before this happened, that they're going to be treated fairly. But what has happened here in this testimony that we're getting today is very disturbing. And I want to say what Mr. Price said. If I were sitting at home watching this on C-SPAN, I would probably be questioning again, well, there doesn't seem to be clarity here. How can I trust? Let me go back to, as I'm listening to your testimony in your opening remarks, you referred to this as foolish mistakes. And then you acknowledged in the response to Mr. Rangel that there was abuse. So this was more than just foolish mistakes, this was abuse. And then you said to Mr. Ryan's response that you felt that the applicants were dealt with fairly. And then you turned around and said, answering to Mr. O'Neill, that there was a litmus test that was a political activity. And you then said politics is always where we ask questions in these kinds of applications. I want to go to page number 6 on the report that does talk about the words that were used, like Tea Party and Patriots, and then at another point in time, issues including government spending, debt, taxes, public advocacy and lobbying to make America better. And I want to know if you say that, yes, there is a litmus test and that politics is always where we ask questions anytime there's an application that seems to go there. Can you give me some other words that would have been used beside what appears to me to be all conservative questions? Was there a progressive that we should look for anything in the application then that says progressive? Was that anywhere?
So I think and I'll refer to Mr. George's statement. I believe his statement indicated what my understanding is, which is this was not the only thing that our folks were looking at as they scanned.
But you're not answering my question. Was there anything in any of this criteria that was outside of what I'm seeing in this report that would have indicated to me that other than conservative groups who were applying for this status, that you had a word in there anywhere to say, okay, the litmus test is this seems to be political. So we always look at political. Where's the word progressive?
I'm not arguing that the list was bad and that the list was conservative based. What I'm saying is more than that.
Excuse me, I'm going to reclaim my time on this, because then I would say it's targeted. You can't have that both ways. That's targeting, and there's 16 times in this report that says that there was targeting. So I believe that as you're giving this testimony that you can't have that both ways. Now, There's also ineffective management that is talked about in this report. And even if you get outside of this and say, okay, there was no targeting, I want to know how a couple of employees that are considered low level could have done what was done here, because this says to the American people that out of thousands of employees that you have at the IRS, there's ineffective management there. Nobody's watching this. If this was noted in 2010 and in 2013 we're just now finding out about this, that certainly is ineffective management, because there should have been somebody that was overlooking this that said, this must stop, and I'm going to come back in 30 days to make sure it stopped. But it continued, and now we've got 400 applications, some of them over 3 years. This is more than ineptitude. I mean, this is more than just mismanagement. And I know my time's going to run out here, so Mr. George, I want to come to you, because you told Ms. Jenkins that you told the General Counsel of the Treasury on June the 4th.
Correct.
You could not recall the exact date that you told the Deputy Secretary, Neil Wallen. Do you recall if it was soon after informing the General Counsel? Was it like a week, a month?
I cannot give a time frame, but I can say that it was shortly thereafter.
Okay. Could we get that date? Is that possible to get that date?
You know, unfortunately, I don't keep a date planner, but I'll do my best, Ms. Black. And
Thank
if
you.
so, if I have it, I will certainly supply it to the committee.
All right, Mr. Reed is recognized. Sorry, time has expired.
I'm sorry. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Mr. Miller, Mr. George, we've sat here for quite some time, and I will tell you that this is offensive. This is offensive to hear this testimony. And what I like to do is, I know you're disagreeing with the word targeting, Mr. Miller. I suggest the American people will make that determination, and I'll give this whole situation a name. It's the IRS targeting gate. I'll put it right out there. And we're going to get to the bottom of it. And we're going to keep on this until we're done. As you sit here today, you were not fired from your job. And I can tell you, in my private experience, you would have been fired on the spot. And all you were allowed to do is resign and retire? And now you come here and somehow try to say, I did the honorable thing by falling on my sword? When nothing bad is going to happen to you. You're going to get your full benefits. You're going to get everything that's associated with your retirement as an IRS employee.
Nothing bad is happening to me, Congressman.
Yeah, financially, you're allowed to retire. That's the level of accountability in Washington, D.C. now. You're still acting. You came here on the taxpayer dollar today. You're getting a paycheck for being here today, correct? Correct?
Correct.
Yeah.
Thank you.
I want to know who, what, where. And you know, when my good colleague, my good friend from Michigan, Mr. Levin, started this, he said, we need to ask the who, what, where, and how. One question he didn't put in his opening comment was why. And we have dodged and weaved this whole time for this entire hearing as to why this happened. And I don't think we're going to get an answer to it today. But Mr. George, I want to get to the bottom of your report, and I appreciate the work you've done. You referenced that there was gross mismanagement in regards to this situation.
Yes.
I want to know who you identified that had the responsibility to manage this situation. I want names. I want to know where they worked, when they worked, and what they did.
Do you want it? Well,
right now.
Lois Lerner is the primary individual who is located in Washington. Joseph Grant was her supervisor. He, too, was located in Washington. And located in Cincinnati, there were a number of people, a director named Holly Patz, P-A-Z. She was the acting director for a significant period of time that this was occurring. And then there were various management, technical unit managers and the like. And I could supply a full listing of those names at your request.
That is my request, and I would formally request that.
But Mr. Reed, may I please beg your indulgence? I need to make something clear in response to both Ms. Black and Mr. Paulson. When I had my discussions with the commissioner and with the secretary and the general counsel, it was not to inform them of the results of the audit. It was to inform them of the fact that we were conducting the audit. And I just want to make sure.
Well, let's follow up on that. When you had that conversation with the secretary, when exactly did that occur?
That happened shortly after he took office. So it was after the policy had already been stopped and the issues have been, we hope, resolved.
And Mr. George, as a country lawyer from Western New York, you made some comments in your testimony about the partisanship determination. You kept referencing something that I've seen many times in my legal career, at this time. That implies to me that there are additional investigations coming down the pipeline that potentially could uncover such information. Isn't that correct?
That is an accurate statement, sir.
And I will be eagerly awaiting those future investigations. And I applaud your work, and I can ask you to continue to do that work. Mr. Miller, I just want to understand exactly, as we just had identified by Mr. George, numerous people in your organization that you had oversight, ultimate oversight for, his ability to identify those individuals. You didn't identify those individuals in any type of management oversight when you became aware of this situation in May of 2012 and reached out to those individuals?
I certainly was aware of my own management chain, yes, sir.
Okay. And so who in your management chain specifically did you talk to about this situation?
After May, you mean, of 2012?
After you became aware of it, you said you talked to your people in your management chain.
I'm sure I talked to Joseph Grant. I probably talked to Lois as well.
Just those two. That's all you talked to.
Well, I talked to the folks who went out and worked on the case, and I mentioned Nan Marks in that regard.
Okay, that was Nancy Marks who was in Cincinnati that you orally disciplined.
No. Nancy Marks was a senior technical advisor who led a team to take a look at this in Cincinnati.
And who was the employee again that you orally disciplined that you thought may had something to do with it?
I apologize, I don't remember the name. We can give it to you. I'll just have to give it to you after the hearing.
And then you said that person who was orally disciplined probably wasn't involved in it, but there was a potential another employee. Who is that other employee?
So let me go back, because there were two employees, one of whom was reassigned, one of whom I asked to be orally counseled. The one that was to be orally counseled, they have informed me may not have been the right person. They pulled all the managers in to talk to them in lieu of an individual that they didn't know which one was which.
And do you have those names?
I'll have to send them to you, sir.
Yeah, I would formally request for the record those names.
All right, thank you. Mr. Young's recognized.
Mr. Miller, I want to know why all of this happened. You and Ms. Lerner have said over the past week that IRS officials started targeting Americans for their political beliefs in March of 2010. That was after observing a surge in applications for status as 501c4s. That was your rationale. To support this claim, you've both cited an increase from about 1,500 applications in 2010 to nearly 3,500 in 2012. But data contained in the IG audit says the targeting began in March 2010, before this uptick. In fact, the audit also says on page 3 that the number of 501c4 applications for all of 2010 was actually less than in 2009. Mr. Miller, you've said here today that you accept the IG report's finding of fact.
Mm-hmm.
How do you reconcile the facts I've just laid out showing no uptick in 501c4 applications with your stated motivation for targeting conservative groups?
So I'll have to go back and look at the numbers, sir, but I think there was an uptick, and whether it's 2008.
You've already indicated here, sir, that you agreed with the findings of fact in the IG report. It says there was no uptick.
I don't.
How do you reconcile the two?
I've got to look at the numbers, sir. I can't speak to that.
So you don't agree with the IG report?
I'd have to look at the IG report on that.
Mr. Miller, in June of 2011, Ms. Lerner learned about the practice of targeting conservative groups for compelled disclosure of donor lists and other information. She learned that was going on for more than a year, whereupon she claims she attempted to put a stop to it. Yet, I have a letter here bearing Ms. Lerner's name, stated March 16, 2012. In that letter, she directs a conservative Indiana group to comply with a previously sent inappropriate information request under penalty of perjury. I have that request here. So 1 year after she said she stopped this practice, Ms. Lerner sent a letter demanding the group fulfill a request she had already determined to be inappropriate, a request that included a demand for donor information. This strikes me as peculiar, to say the least, and it seems to contradict claims that somebody at the IRS tried to stop the harassment in 2011. Further, this Indiana group had their 501c4 status denied on February 18, 2013. But 4 days later, on February 22nd, 2013, their 501c4 request was granted. even though they never provided the required information. So after seeing these actions and an approval of an application that looks a lot to me like someone was covering their tracks over that 4-day period, how can I assure my constituents that employees of the IRS aren't targeting conservative groups they disagree with?
So let me put this in sort of time order, because I think there's, again, there's some fundamental mashing of issues. There are two issues here. One is the list issue, which began about the time you say it did, I believe, and one is how we processed the cases. The donor list letter, and I'm not speaking because I don't know that case, but the donor list letter issue occurred much later in time. It actually occurred, I believe, and I'll have to go back and check this, but I believe it occurred after Lois had stepped in and stopped the listing, the first issue. The development of those cases was still problematic. We had not gotten to the bottom of that, and that's why that would have been the case. I don't have an answer for you on the last piece of that.
Wait a second here. She said she'd resolved this situation. She said she had stopped the targeting of conservative groups. A year later, she demands a group fulfill a request for the inappropriate information. I don't believe you've addressed that issue, sir.
So,
You've got 30 seconds left to do so.
I apologize. First, you should know, while her signature is on there, her signature is on 70,000 applications, so let's not personalize this one to Ms. Lerner. Secondly, and probably more importantly, I mean, I think that, again, my understanding and what I think Mr. George has said is that in 2011, June or July, whatever it was, she handled and fixed the list issue. The cases were still in development. The cases needed to be in development. There were issues. We just did a remarkably bad time of it.
All right, sir. And then it's just curious, I'll reiterate, a denial on February 18, 2013, and then a granting 4 days later. It does look a bit fishy there. We'll have to clarify that.
Time has expired. You'll have to respond in writing. Mr. Kelly.
Thank you, Chairman. Mr. George, you have been on the job since November of 2004, is that correct, in your current position?
2004.
Anything rise to this level before?
No, nothing.
Can I ask you, why did it take so long from the first time we knew that this was happening to got the report done? I met the President said just the other day, I think it was yesterday, that he just got a look at the report, and that's the first time he knew anything about it.
Well, first...
Other than reading it in the papers, I guess.
Are you asking how...
yeah, so have you ever seen that magnitude before? Anything of this magnitude before?
No.
It's never come up before?
No, it has not.
Okay, all right. Thank you. Mr. Miller, now you've been on the job for quite some years, but the current job you're in is from November 9th, 2012. So is that right? So you just took over as acting commissioner?
In November of 12, yes. I have both jobs.
All right. But before that, one of your jobs, you were the Commissioner of Tax Exempt and Government Entities Division. So you actually were in the job that we're questioning now, that group of what was happening there. So would you have been in Cincinnati?
No.
You were never in Cincinnati?
No.
So is Cincinnati some outpost?
So obviously the IRS is a nationwide organization.
Oh, I know, I understand that.
300
I understand that. And I want to tell you, listen, believe me, if you think it's uncomfortable sitting over there, you ought to be a private individual when the IRS is across from you questioning. So I got to tell you, it's uncomfortable for everybody. But my question more specifically is, so how did Cincinnati get to where they are? How did they develop that strategy? And how did they know to go after these certain groups? How did they target those folks? That just couple rookies just showed up, didn't really know what they were doing?
So again, I would point to the TIGDA report on what happened.
No, I understand that. But I'm hearing these are low-level people that push the wrong button. Now, when Cincinnati can't figure out, who do they confer with? Who's their counsel? When they're looking at these entities, tax-exempt entities. Does it come back here to D.C.?
There's two possibilities.
Yes or no? Does it come back to D.C.?
Yeah.
Okay, all right. So D.C. and Cincinnati will be pretty well connected in understanding what's going on. So this doesn't come as a great shock to anybody. In fact, I would say it doesn't come as a shock. You know what it does for the American people? It really establishes what they feared so often. I have a grandson who's afraid to get out of bed at night because he thinks there's somebody under the bed that's going to grab him. And I think most Americans feel that way about the IRS. I mean, you get a letter from you folks or a phone call, It's with terror that you look at it. And now this kind of reconfirms that, you know what? They can do almost anything they want to anybody they want, anytime they want. This is very chilling for the American people. Now, I know that where you're at, you're resigning, you're walking away from it. But this is not going to go away. This is a Pandora's box that has been opened, and I don't think we can get the lid back on it. And I don't believe that the White House just found out about this in a news report. The president happened to grab a TV shot or just read Mr. George's report and said, you know what, anybody heard about this before? I'm just getting a first look at this. Shouldn't somebody be responsible? And I'm thinking maybe the executive office, maybe Treasury falls in there. I'm not sure that we understand how that organizational chart works. But I am really concerned. Now, I got to tell you, where you're sitting, you should be outraged. But you're not. The American people should be outraged, and they are. And this committee, this has nothing to do with political parties. This has to do with highly targeted groups. This reconfirms everything that the American public believes. This is a huge blow to the faith and trust that the American people have in their government. Is there any limit to the scope of where you folks can go? Is there anything at all? Is there any way that we could ask you, is there any question you shouldn't have asked? My goodness, how much money do you have in your wallet? Who do you get emails from? Whose sign do you put up in your front yard? This is a tax question? And you don't think that's intimidating? It's sure as hell intimidating. And I don't know that I got any answers from you today. And I don't know that what Mr. George has done is great work. But you know what? There's a heck of a lot more that has to come out in this. And anybody to sit here today and listen to what you have to say, I am more concerned today than I was before. And the fact that you all can do just about anything you want to anybody, you know, you can put anybody out of business that you want anytime you want. And I got to tell you, you talked about you're a horribly run organization. If you're on the other side of the fence, you're not given that excuse. And when the IRS comes into, you're not allowed to be shoddy. You're not allowed to be run horribly. You're not allowed to make mistakes. You're not allowed to do one damn thing that doesn't come in compliance. If you do, you're held responsible right then. I just think the American people have seen what's going on right now in their government. This is absolutely an overreach, and this is an outrage for all America. I yield back.
All right. Mr. Griffin is recognized for 5 minutes.
Thank you, Mr.
All right. The committee will come to order. We'll have order in the committee. Mr. Griffin's recognized for 5 minutes.
Thank you, Mr. Chairman. I want to make a couple comments first. You know, the surge in these groups that are the subject of this hearing is not related to a Supreme Court case, if there was a surge at all. It's related to the nonsense in Washington. That's why people were getting engaged. In fact, the Supreme Court case that's been so much discussed here has no bearing on these groups. Ultimately, that's ridiculous. What this hearing has demonstrated for me that our most expansive federal powers are given to our most intrusive agency. And then you add on top of that incompetence or whatever else we have, and it's a disaster. You know, my colleague here talks about asking people how much money they've got in their wallet. I got a text last night at dinner from a friend of mine who's a supporter in Arkansas, in Little Rock. He's being audited. Yesterday morning, he had to meet with the IRS. He was outraged. He sent me a text. He said, they asked me, how much cash do you carry in your wallet? How much cash does your wife carry in her wallet? Do you use the internet? You know, I don't care what rules are written down or not written down. These people ought to have enough common sense to know that this is just stupid to ask this kind of stuff. And if they don't know that on their own without something written in a regulation, they ought to quit or be fired. It's craziness. Now, I've known you for a long time, General, and I've looked at your investigation. I appreciate the work you've done. It's really an audit. Let's be clear to the press. This is not an investigation. You did not request emails. You did not do what you would do in an investigation. There's a reason you don't know who came up with this. You didn't investigate that. You might be now. Are you?
I'm not in a position, sir, to discuss whether or not.
That means you are, okay. So the bottom line is, the bottom line is, for those looking, this is an audit, and it's helpful, but it's the tip of the iceberg. It's the tip of the iceberg. It's looking at metrics and interviewing some folks. We worked together years ago up here on the hill, right in the building next to us. And we know how important emails are. And I trust that you're going to get to the bottom of the emails. Now, let me just mention real quickly. If you want to know where a lot of this comes from, look at Senator Levin's letter. Senator Levin specifically mentioned a bunch of the groups that y'all targeted. The other senators made the points, but they didn't mention specific groups. It was Senator Levin's letter. To some extent, y'all were doing what Democrat senators were asking. A lot of the press here ought to go to the Senate when you're done and ask them some questions. Now, with regard to Sarah Hall Ingram, you may have been confused as to when she worked there, but she was there from 2009 to 2012. You said you had horrendous customer service. And what happened to her? She got $100,000 in bonuses, and she was promoted. Wow. Incredible. You said the buck stops with you. Well, it stopped with her before that. She was directly in charge of these rules, of this targeting. What'd she get? Bonuses, and moved to a job. And you know what her job is now? She's coordinating Section 1414 of Obamacare. What is that? That's the provision that says that there is an exemption or an exception to disclosure of tax information. What is that? That means the Treasury can share your tax information with HHS for the purposes of implementing Obamacare to see whether you have got a really expensive health care plan or what have you. It's right there in Section 1414. So she provided horrendous customer service under her watch, and now she's going to do the same implementing Obamacare. Swell. This is a perfect example of why we need tax reform. If you want to diminish and limit the power of the IRS, you've got to reduce the complexity of the tax code and take them out of it. Thank you, Mr. Chairman.
Thank you. Mr. Renacci is recognized for 5 minutes.
Thank you, Mr. Chairman. Gentlemen, as a CPA who's represented many taxpayers in the last 3 decades, I am really appalled. I'm really appalled that the agency was able to take these actions. Mr. George, you made a comment. You said that these actions, even though they were contrary to the Treasury policy at the IRS, it was not illegal but inappropriate. Mr. Miller, if a taxpayer was in front of your agency and they did something that was contrary to Treasury policy, would that be illegal or inappropriate?
If they did something contrary, no. It would
Treasury policy on their tax return?
No, we would be auditing them.
I know you'd be auditing them, but I've seen your agency bring people to tears because you say it's inappropriate. It's just amazing the way you're answering some of these questions. You know, you answered a question, Mr. Roscom, you said, I don't know. If an American taxpayer said to you in an audit, I don't know the answer, what would your agency do to that person?
We would work with them.
I've seen what you've done to them when they say they don't know. That's the problem. That's what the problem here is. Mr. Miller, you talked about you were out, at some point in time, you said these were serious infractions. You said you were outraged. When did that become, when were you outraged? When did you first learn of this, and when did you become outraged?
May 3rd of 2012.
So May 3rd of 2012, you became outraged. When you testified in front of this committee on July of 2012, why weren't you outraged then?
I was answering the questions that I was asked, sir, and I knew that TIGTA had this under its viewing, and that this was going to come out.
But you were outraged a couple months before. You didn't let Congress know of your outrage at that point in time.
At that point in time, I fixed the problem.
It fixed the problem. Mr. Chairman, I want to offer in the record a statement from one of my constituents, the Ohio Christian Alliance.
Without objection.
The Ohio Christian Alliance is one of those organizations. Now, they were applying for a C3. an educational trust. They were there, they were advocating life, faith, and freedom. Is there anything, what was the IRS concerned about? What were they scared about when it comes to life, faith, and freedom?
Sir, I can't speak to an individual case. I have no knowledge of that.
I'm just using an example. Life, faith, and freedom, that's something that the IRS would pull an application for, and actually it took over 13 months. The timeline on this, they filed in February of 2011. In March, they were told they'd have an answer in 90 days. In December, they got a letter that said they had 2 weeks to respond or their application would be denied, and then they responded. By the way, some of the questions, you talked about what are some of the questions. I mean, they list here, is your organization or were the actions of the organization against anti-Christian bigotry more accurately classified as education in nature if the organization is engaged in such activity? I mean, are some of those questions appropriate?
Don't know, because it's a specific case, but I will say one of our difficult areas is determining what's politics and what's education. It's a very difficult line.
I don't think anything in this application leaned toward politics. It leaned toward, as I said, life, faith, and freedom. Mr. Miller, I understand that after the presidential election, the IRS approved dozens of applications from conservative groups. Why was there such a large approval after the election?
I don't have that information. My information is that in May, I asked that the cases be grouped in a fashion that we move them quickly through and tried to fix the process problems we had. There were a number of applications from Tea Parties and others that were approved at that time, and we pushed hard.
Was there a process changed post-election?
No, not that I'm aware of.
Okay. Mr. Chairman, I yield back.
Thank you, Mr. Renacci. That brings this hearing to an end, but I promise the American people this investigation has just begun. Hearing adjourned.
Bridenstine wanted to meet with us for a few minutes, so if you want to go do that before everyone runs out.
Susan's got it. She's got it. All right, go.
Thank you so much, Ken. I'll call you back when I have more time.